SJC-12208, Commissioner of Administration and Finance v. Commonwealth Employment Relations Board.
Mr. Merrick, good morning.
Good morning, Your Honor. Assistant Attorney General Rob Quinnen on behalf of the Commissioner or Secretary of Administration and Finance. In April of 2009, the state executed 2 collective bargaining agreements with the Coalition for Public Safety, otherwise known as COPS, that called for no wage increase in fiscal year 2010, only a 1% bump in fiscal year 11, and then somewhat more generous raises the subsequent 2 years. By June of 2009, however, Governor Patrick was warning state legislators of an unprecedented state budget gap of nearly $1.5 billion. A year later, when state law mandated that the Secretary of Administration and Finance seek funding from the legislature for the COPS agreement's initial 1% wage increase, there was still no end in sight to the fiscal crisis. In June of 2010, a key moment in this case, given that it's the date of the letter that's being challenged here, the National Association of State Budget Officers concluded that fiscal year 2010 had presented the most difficult challenge for states' financial management since the Great Depression. Every other union, save one, had agreed to forego wage increases for a second fiscal year to avoid further employee furloughs or even more painful cost-cutting measures. Against this backdrop, the then Secretary of A&F felt compelled to advise the legislature, as he fulfilled his statutory duty to seek funding for the negotiated wage increase, that he had not succeeded in obtaining a similar concession to economic realities from the COPS union, and that if the legislature funded a wage increase for them, it would trigger reopener clauses in the other unions' contracts. The question this appeal poses is whether it was unlawful for the Secretary to communicate candidly with the legislature about the fiscal pressures posed by the COPS agreement. At the same time, he discharged his duty to present the proposed contract for funding. The governing state law set forth in Chapter 150E does not forbid the Secretary's actions. Section 7B of Chapter 150E provides that where full implementation of a collective bargaining agreement requires an appropriation, the employer, quote, shall submit to the appropriate legislative body a request for an appropriation necessary to fund the cost items, close quote. The section places no other requirements or limitations upon the employer. The employer must simply present an appropriate appropriations request,
So
period.
the letter we're talking about, was that part of House 1?
No, it was subsequent to House 1
Okay.
because the agreement was not executed until April of 2009, and House 1 usually issues before that
And
date.
so at the time, I can't remember the statute, maybe Chapter 29, but at the time, there was an obligation of the executive branch to actually inform Ways and Means of the implications, the fiscal implications as it related to various agencies. And I assume your position is that what's within this letter is also part of that obligation.
Yes, Your Honor, exactly. There was an ongoing statutory duty. We argue that there was also a constitutional prerogative, the recommendations clause. In conjunction with any submission of a funding request to the legislature, the governor, and by extension his chief fiscal officer, is exercising the constitutional budget recommendation authority.
But you can understand the union's position is if you can enter into a collective bargaining agreement in good faith and then just send a cursory letter that basically says, for anybody who understands the building, don't fund this, that's not really collective bargaining in good faith.
That would normally not be a good practice. Now, what we have here is a very unusual circumstance where more than an entire year had elapsed between the time that a prior Secretary of A&F had executed this agreement with the COPS union and a precipitous drop in state revenue in the ensuing 14 months. So circumstances really had changed dramatically. And it's our position.
They had agreed to the pay raises, even though the circumstances had changed.
At the time, what they agreed to was a 0% salary increase for the first year.
Right.
And then subsequently, there would be a 1% wage increase.
Right.
Now, again, 14 months had elapsed. there was this unprecedented drop in state revenue. And all that the Secretary did, he did request the funding, but all he did was to inform legislators of the possibly quite severe financial ramifications of funding even just this one contract.
And how is this different from the Framingham case?
Well, the Framingham case, of course, involved municipal.
Right.
And here there is an entirely different overlay of constitutional authority on the part of the governor, which distinguishes it quite a bit from the Framingham case.
Well, in Framingham, it was said you should only do this on the condition that a 2.5 override is passed. It was a conditional request.
That's right. That's the other respect in which Framingham is a completely different case,
But
because
what if Mr. Gonzalez had been even blunter than this and said, I know we entered into this deal, the state can't afford it, you should not enact it?
well, there have been instances where this court has authorized a public employer to outright oppose an appropriation, even in the instance in which it is the employer itself that negotiated an agreement and is presenting it per its statutory duty.
So that would have been fine. It's not an issue that he could have gone further as far as you're concerned and says, because of this budget crisis, I urge you not to fund it. We can't afford it.
Under these circumstances, given this passage of time and what had happened, I think that's correct.
Okay, what if there were evidence that before he entered into the collective bargaining agreement, before he signed it, he knew or that he knew that he was going to go to the legislature and say, don't, we can't afford it. I didn't have the courage to say no, but I ask you not to fund it.
That might raise a question of the Secretary's good faith.
Might or would?
Well, it could.
Well, I mean,
It
let's
depends
assume
on-
the facts were clear. Let's assume the evidence was clear that he understood on the date that he signed it. Let's assume there was a writing that said, I'm going to sign this thing because I don't have the courage not to, but I intend, when I ask for funding, to say, I'm doing what I have to do under 7B, but we can't afford it.
In that circumstance, I believe there would be a good faith problem. And so sections 10A5 and 6 of Chapter 150E would come into play.
Well, who's the fact finder in that scenario,
It could be a hearing officer with the Division of Labor Relations.
which is what we have here?
Here, it's important to note that there was not a single finding of fact made by the hearing officer or the Commonwealth Employee Relations Board that supports the finding of bad faith.
But it's still 30A review.
That's,
Yeah.
that's correct.
Right. And the board basically, I think, is saying, takes more than a ministerial act if you're going to enter into a collective bargaining agreement.
Well, the act under Section 7B is more in the nature of a ministerial act of requiring that there be a submission of an adequate amount that's unconditional, and that did happen here. And the only other question is whether what the Secretary said is evidence of bad faith. But as I said a moment ago, there was absolutely no finding whatsoever of good faith and of lack of good faith. And it would be really incomprehensible to think that a new Secretary of A&F, he was not Secretary of A&F at the time that the agreement was signed in April of '09, that he somehow would have been acting in bad faith because of this great downturn in state revenue in making the communication he did to the legislature.
Or would it have mattered if his predecessor had written the diary entry I mentioned? And if it had turned out that he had told his successor, I signed it, but you should not ask for funding?
Well, I don't think really there's anyone, Warren Buffett included, who can accurately forecast more than 12 months in advance what fiscal conditions are going to be like.
Well, that's not, I mean, but that's a separate issue. I mean, a separate issue to say, we need this collective bargaining agreement to be signed. We need these folks to be working. I'm going to sign it, but I know that there's no consequence unless there's funding. So I'm going to sign it, get them off my back, But I'm not going to, and I'm going to ask for funding, but I'm going to give them the wink and the nod and tell them, please don't fund it.
Well, the unions have to know that in order for any collective bargaining agreement to be finally effective, it requires an act of the legislature, and it also must survive the governor's review.
Okay, I understand that, but I'm trying to get a sense of, you argue constitutional entitlement. I'm trying to figure out whether your view is that the A&F can act in bad faith and that they have a constitutional entitlement to act in bad faith with regard to executing an agreement which they, when they sign it, they know that they're going to be asking to not fund.
No, I'm not arguing that A&F has a constitutional right to act in bad faith.
So bad faith is separate and apart from your constitutional argument.
That's right.
So in your view, this is essentially a bad faith test, not a 7B test.
Well, 7B has been satisfied. I don't think there's any dispute.
Okay, so your view is 7B is satisfied. He made an unconditional request to say, here, I give it to you.
Right.
But you're saying the real issue here is whether or not he acted in bad faith.
That's right. And that there was absolutely no finding of fact made by the Commonwealth Employee Relations Board to support a finding otherwise.
So if you're right, what do we do? Do we remand?
No, I think the decision should be vacated, and certainly the remedial order should be vacated.
Okay, it's vacated and then remanded for the possibility of making findings with regard to bad faith, or because the decision below rested on 7B?
Well, I think, again, given the fact that we're talking about a different Secretary of A&F that wrote the letter.
Okay, you may win on the bad faith. I'm just trying to figure out procedurally what you say to be the outcome.
Well, procedurally, the Commonwealth's Employee Retirement Board's decision should be reversed because it is not based on proper findings.
Weren't you also arguing that the interpretation of 7B was an error of law?
To the extent that they say that there was some failure under 7B to properly make a request, that would be an error of law.
So all the board decisions then, I mean, whether it's Rockland or the Taunton case, you would say those were all wrongly decided by the board?
No, first of all, those have to do with municipal employers, which involve a whole different set of considerations. And secondly, some of those cases deal with a mayor, for example, who simply refused to make a timely request. That did not happen here. So those are different cases. What we have here is a simple transmission of highly salient information to the legislature at the time a proper appropriation request was made. And open channels of communication are vastly preferable to back channel or the logical outcome of SERB's decision here is for there to be hypocrisy, for there to be a promise made and then happy talk from the Secretary of A&F, perhaps to be followed by a gubernatorial veto.
Did he have to, I know there's a statute that says he's supposed to transmit information, but did he have to in this situation? I mean, he had already done the 7B thing, and then did he have to say what he said in the letter, referring to the unions, the other unions that had agreed to, I guess, they revised their contracts and agreed to give backs or something like that.
Right.
I mean, why
Well,
did
I
they
think
need
that-
to know that?
I mean, that happened for two reasons. One, the letter itself says that it is a follow-on, that this is additional submission, and the legislature should know that it's related to the prior collective bargaining agreements that were not funded. But more importantly, the real point that the Secretary was making is that funding of this agreement would trigger reopener clauses in every other union contract, which would be fiscally very, very damaging.
And that is, I gather, a provision that says if anybody does better than we do, we renegotiate.
That's right. That's right. And I also just want to make the point that implementing the remedy ordered by SERB now would be pointless frankly, a charade. And it could be harmful to the union. It could cause confusion because right now there is pending before the legislature a request to fund a new 3-year series of collective bargaining agreements with a more generous salary increase schedule. And so if the legislature sees this one being resubmitted with just a 1% increase in the first year, that probably will confuse them because what is pending actually is a request from the administration to fund them for 2% increase, followed by 3% increases in the next 2 years.
Going back to Chief Justice Gantz's questions and the constitutional issues, why would the constitutional issues change if there was bad faith? The executive branch and the chief administrative officer and the Secretary of A&F, they have certain obligations and they have certain constitutional responsibilities. And so, based on the argument that you made on your brief, why wouldn't the answer to the bad faith be the ballot box?
Well, I suppose one could take that position, that the only remedy for bad faith is at the ballot box.
But if you don't take that position and you follow Chief Justice Gantz's arguments, then you have no constitutional argument that's left. Unless the ballot box is the answer, there is no constitutional argument.
Well, I think here, the important point is that what the Secretary was engaged in was exercise of the recommendations clause authority. And that really cannot set up a bad faith scenario where he is entitled by the Constitution to give his honest recommendation to the legislature.
I completely appreciate that, but going back to the Chief's probing was trying to figure out the limits of the constitutional argument. And as I understand your constitutional argument, the bad faith would not impact the constitutional argument. In other words, we'll sign the collective bargaining agreement, but we'll have our fingers crossed behind our back when we do it, would not change the constitutional argument based on, at least on your brief.
That may be so, but it's also important to point out that this is not the case we have before the court.
I appreciate that.
Okay, thank you.
Thank you.
Ms. Gabriel, good morning.
Good morning, Jane Gabriel on behalf of the Commonwealth Employment Relations Board. I will be arguing for 10 minutes and the intervener will argue subsequently to that. The courts posed the question for amicus briefs whether or not the Secretary was required to do anything more than submit. So up front, I'd like to try to clarify what the board means when the board talks about support. The board's case law is clear, and UMass case that's cited in the brief says clearly that proactive advocacy is not what's required. What's required is that a statutory employer does not submit a request and at the same time signal a lack of support, or that a statutory employer does not stand silent in the face of opposition while he or she is making that request for funding. What the Secretary did here is very clear. The Secretary signaled a lack of support. They've admitted as much. The information that they gave, which was not required, was not necessary, was beyond the scope of anything that Chapter 29 talks about, was in bad faith. It was a violation of its good faith bargaining obligation.
How do we measure that second prong? Because I get the first part where you can't signal a lack of support, which the letter clearly does. But the second part of that requirement that they can't remain silent in the face of opposition, how are we or anyone else, a fact finder, supposed to measure how effective the A&F Secretary was, or what type of cheerleading they did or didn't do for not to be a labor violation?
Well, there are two answers to that question. I think in this case, Your Honor, there's absolutely no question that what the Secretary did was negative. What the Secretary did was get up and said, please don't fund this.
Well, we got a letter, so it's easy.
Okay, correct. But what the board does in the board's cases, and its charge is to interpret Chapter 150E, what the board does is it looks at everything on a case-by-case basis, and its cases say as much. And so there are a number of cases that this court has in fact cited to in the Framingham case, which evaluate the factual circumstances. So, for example, in a Worcester case that the court cites too, the alternative funding was available. The employer did not seek alternative funding. He was required to in good faith. In another instance, the mayor refused, another case that this court cited in the Framingham case, the mayor refused to go before the funding body and ask for the money because of the funding, because of a quote-unquote tax cap. What the board did was the board evaluated that case and found that the funding authority could override the tax cap. So what the mayor did was not good faith bargaining. The mayor had to submit it and let the legislature, the funding body, do its job.
What's at stake here? Because the union ultimately got their money, right?
I'm sorry?
What's at stake in this case? Because the legislature eventually appropriated the money for the costs that were involved in the contracts, right?
Right. There are actually, what happened was the contract that was funded on the last day of the first year. So there's still 12 months that the members of the union did not receive that first year pay raise. But in addition, this is a serious question, and it's time for this court to hopefully affirm the board standard. This is going to come up again. So this is a question that's going to repeat itself.
The appellant's position is that all the cases that you've cited deal with municipalities, with mayors, and here we have the governor, and it's a different constitutional issue.
Well, you know, I'd submit to the court, Your Honor, that very clearly, the governor is not the statutory employer. This is the legislative scheme. Chapter 150, Section 1 defines a statutory employer. The statutory employer is the Secretary of A&F. It's not the governor. The governor is a separate entity in this case. The secretary appeared that day as the statutory employer and said as much.
But you must know that the difference between the Secretary of A&F and the governor is no difference at all.
Well, actually, Your Honor, I suggest that there is a difference. In this case, the legislature set it up so that the statutory employer is the Secretary of A&F, not the governor. And maybe in its wisdom, the legislature anticipated a situation like this.
But that's the last day the Secretary of A&F is going to have his job if there's a difference between the Secretary of A&F and the governor.
Your Honor, often there are conflicts in our roles as government employees. And in this instance, with the secretary that day, I can't say it any differently to Your Honor. That day, the secretary was the statutory employer. Had the governor wanted to get the message to the legislature in a different way through a different designee from a different department, he could have done so. But that wasn't the case here. The secretary stood there not as two people, as one role, as the statutory employer who had entered into an agreement with the union and was obliged to submit that in a way that the legislature would believe that he was honoring his agreement. I'm not saying put on a show. Sometimes submission is support. All it takes is to go before the legislature and say, I've entered into this contract, I've come to this agreement, I'm asking you to please help me fulfill my bargaining obligation, my agreement, and please fund this.
And the governor's chief policy advisor could have sent the same letter the same day?
I believe that, you know, you'd have to evaluate the facts, but yes, I do believe that the governor, had he wanted to, gotten the message to the legislature, but not the statutory employer. Once again, it's a statutory scheme that we're stuck with.
So if no letter had been sent, and the chair of House Ways and Means sits down with the head of A&F and says, what are we going to do with this contract? Tell me, is this contract the same that you gave to other unions? And if we do fund it, are there consequences with regard to those other contracts? What's the head of A&F supposed to do?
Your Honor, actually, I'm glad you asked that question, because had the questions been put to him, he would have had to be honest. He would have had to answer the questions. And had that happened, the board would have had an entirely different case before it, and the evaluation would have been very different.
So he's obligated to ask the question, but of course the concern is they don't. They fund it, and then it turns out that they're renegotiating it, and the head of Ways and Means is ballistic because he said, no one told me that this would have this consequence, and you're supposed to look after us, and you basically didn't tell me that funding this contract would affect not only this contract, but 2 other contracts.
Your Honor, this request isn't the, with all due respect to the Secretary's role as a statutory employer, it's not the be-all and end-all. The legislature can deny the request. The governor can veto the request. The governor can get the message to the legislature in another fashion. But there is nowhere in the history of the case law in this court where this court has adopted the board's language, the unconditional language. There is nowhere where anyone has distinguished the governor as an employer from any other municipality. So had that scenario happened, Your Honor, yes, the secretary might have had to stand there and take a beating, but his job was a statutory employer. That's his very reason for being there that day. He wasn't even in the main budget. He wasn't even in House 1. It was a separate submission. He came as a statutory employer. That's what he presented. That's what he presented. That was his obligation that day. The union didn't have a voice that day. They walked away from the bargaining table, and he had an obligation to support his bargain.
So is your argument that this is required by 7B, or this is required pursuant to the separate obligation to negotiate in good faith?
Your Honor, 7B isn't read in isolation, and this court's recognized over and over again the comprehensive scheme of Chapter 150E. It has to be read together. This is a violation of his good faith bargaining obligation found in Section 6 and enforced by Section 5 of Chapter 150E.
I don't understand the purpose, though. If the legislature can get the information, say not from the secretary, but from other venues, other ways, why are we here?
The question makes sense, but isn't that what happens every time the governor submits a budget? The governor submits a budget, the legislature evaluates it, and then it goes to the governor or doesn't go to the governor, and the governor can veto it. It's the scheme, it's the way it's set up. So if the legislature could get the information otherwise, again, I emphasize that the secretary was there as the statutory employer, not as an advisor to the legislature at that point. So it makes sense, although it appears to be a conflict, because that's what we were given by the legislature. That's the way it is. And because that's the way the statute is written, because the statutory employer is required to go before the legislature and make an honest submission, which the board has termed support, that's what he was required to do.
So if everyone stays silent, it goes to the governor sends a note to the head of ANF, should I sign this? He says, no, we can't afford it. Is that the same thing?
No, Your Honor, it's not the same thing, because then he stands in the shoes of the advisor to the governor as his financial officer. How does this to swallow? What for the court perhaps, what is the alternative? Who then goes before the legislature? Can the statutory employer go before the legislature then and give the mixed message, which isn't a mixed message at all in this case? And I ask you to, please, stay focused on this, in this case, not that I'm telling the court what to do, but if we stay focused on this case, the facts are really clear what the secretary did here. This isn't a borderline case. And if I could, there is one point.
Is it a violation if it's not bad faith? Is it a violation of the duty to bargain fairly if it's not bad faith?
Well, Your Honor, if it's not good faith, it's bad faith. And this was not good faith bargaining by, just looking at the letter. So, he violated his good faith bargaining obligation, which is bad faith.
Well,
Bargaining took place.
Sorry, maybe I didn't understand your question,
No,
Your Honor.
it was
I'm
from down
sorry.
there.
The bargaining took place before the letter, so the bargaining, the
Oh, I
agreement's in
see,
place.
I see. You know, one of the justices asked a question earlier about had, you know, he not entered into the agreement, would that have been bad faith? I'd suggest exactly the opposite of what the Secretary has said today. If you haven't entered into the agreement, there can be an exigent circumstances, there can be an exigency defense, but in this case, the deal was sealed. The contract was signed. As a practical matter, I think that the parties tried to go back to the table and negotiate something. I am not a party to that. That didn't work out. The Secretary was stuck with his bargain. I'd also suggest that the Secretary, you know, the fiscal situation here, I think that this contract was entered into in April of 2009. The governor's letter came in June of 2009. I've worked for the state for a long time. I remember that very well. The fiscal situation was tough, but still the Secretary entered into the agreement. There may have been a time to speak to the governor before he signed the agreement, but after he signed the agreement, the deal was done. The parties were not able to renegotiate. The information that the Secretary brought before the legislature is information that was not required. I mean, if you think about it, if the Secretary, if every statutory employer would go before the funding body and say to the funding body, well, this is what happened at the table, and these are the compromises that we made, then nothing would ever be funded if you discussed the bargaining history and what happened at the table. So I suggest to the court that, again, you ask about bad faith, this is clearly not good faith, as, by the way, the board did find that this was, that the letter was a violation of Chapter 150E's good faith bargaining obligation. Is there anything further? Okay, I went over my 10 minutes. Thank you for your time.
Thank you.
Good morning, may it please the court. Alan Shapiro, representing the Intervenor Coalition of Public Safety. My clients signed 2 collective bargaining agreements with the Commonwealth in the spring of 2009. The first one was for no raises. The second one was a 3-year collective bargaining agreement with 1% the first year and 3% in each of the subsequent years. That was a kind of model that other unions were following in the state at the time. In the intervening period, when the Commonwealth went to the legislature and discussed the funding of those other agreements, they were told by the legislature that they were not going to fund them, or there were issues about funding them. So they went back to those other unions, and they got the other unions to defer the raises for 364 days. So the agreements were still the same percentages, but the raises came on the last day of each of those 3 years. My clients did not want to defer, and they were willing to take their chances in terms of getting the agreement funded by the legislature. So in terms of the damages would really be the difference between getting the money in the beginning of the year and getting the money at the end of the year for those 3 years. By June 30th, 2013, my clients were in the same position they would have been in if the original contract had been funded. So there's a scheme that Chapter 150E sets out, and that the Department of Labor Relations has worked into the law in terms of this somewhat labyrinthine process of funding collective bargaining agreements. The executive branch negotiates with the union, and then the executive branch is supposed to do what it can to try to get the agreements funded. It's always left to the legislative branch to do what it wants in terms of funding those agreements. But if the executive branch is going to be able to somehow give negative feedback or do something to jeopardize the funding of those agreements, then I think we're looking at a situation where collective bargaining is going to be extremely difficult, not just on the Commonwealth level, but on the municipal level as well. So the other issue here is there's a discussion about bad faith. Unfair labor practices under Chapter 150E, Section 10, as well as the cognate federal statute, National Labor Relations Act, it doesn't necessarily involve moral turpitude. Labor agencies define breaches of the labor statutes, in this case 150E, Section 10, based upon their view of how the labor laws are supposed to work with reference to the particular issue at hand. So with reference to the funding of collective bargaining agreements, there's a whole bunch of cases cited in the Framingham case of Labor Relations Commission cases where they talk about different ways that employers fail to live up to their obligations in terms of funding contracts. Those are not necessarily mala in se. Those are simply the board's interpretation of what is an employer's obligated to do to seek funding.
So where does the board get that? I'm just looking at the decision, and from what I can gather, the board does not cite 150E, the board does not cite the duty to bargain fairly statute. It relies solely on 7B.
Well, I think, Your Honor, that the actual violation is a violation of Section 10A5.
Well, the board didn't say that.
I believe in the, I don't have it in front of me, but I think that the only unfair labor practices are committed under Section 10 of
Right.
Chapter 150E. There is a ministerial function in Section 7B. The board and its predecessor, the Labor Relations Commission, has read into that the duty to bargain in good faith with the ministerial function, the additional responsibility to try to fund collective bargaining agreements that were negotiated in good faith.
One factual question. The collective bargaining agreement was entered into on April 28th of '09?
Correct.
The letter from,
Two contracts, sir.
both on that date?
I believe so, yes, sir.
The letter at issue, I think, is dated June 9th of 2010, is it not?
Yes, sir.
Okay, so it's not 2 months after the agreement, it's 14 months after.
No, it is because I believe, so the zero contract, there were no additional cost items to be funded, so the funding for the first year where there would have been a pay increase would have gone in the spring of 2010 for a collective bargaining agreement effective July 1st of 2010.
So this is funding essentially for the second year of the contract? Because the first year...
First year of a
didn't
new
generate any.
3-year collective bargaining agreement.
Right.
Do you agree that this, if the Secretary of A&F sent a perfect letter that in every way complied with Section 10, and on the same day, somebody from the governor's office sent a letter to the chair of House Ways and Means that funding this would be a disaster, that there wouldn't be a good faith violation?
No, I don't agree. I think that that would create a sham out of collective bargaining.
Well, then why doesn't the Secretary of A&F have an obligation to the legislature and to the public to indicate the fiscal implications of funding?
Well, the Secretary of A&F, as Attorney Gabriel pointed out, wears different hats with respect to the funding of this particular collective bargaining agreement, he had entered into a contract with a union which bound him to seek funding for it. In his other roles as advising the legislature in a fiscal sense, we're certainly not saying that he's not obligated to present a true picture of the Commonwealth's fiscal situation. But in terms of actually seeking the funding of this collective bargaining agreement, his duty is to simply support it and do what's needed to try to fund it.
Could he veto it?
Obviously, the governor could veto it. It's constitutional. Whether that would be create additional unfair labor practice, I don't know, but there's certainly no question that it could be vetoed.
Okay, thank you.
Never happened. Thank you.